it appears as though Mr. Howard does not, or Mr. Howard Randolph does not quite fully grasp the no contact, specifically threatening contact, which is why this court had serious concern as to the safety of Ms. Duff earlier when nobody had heard from her. Pamela, can you please unmute?
Yeah, hello.
Okay, good morning. All right.
Good morning.
So, all right. So I understand that there was some difficulty with your vehicle, correct?
Yes.
Okay. All right, Mr. Kazak, are you ready to proceed?
Yes, we're ready to proceed, Your Honor.
Okay, I think we're just grabbing Mr. Shumke, and then we will. Okay, Ms. Duff, can you? Well, I'm just going to have you mute when you're not addressing the court, just because we can't have the background noise on the record. Okay.
Okay.
So we are recalling the matter of the City of Michigan versus Dean Howard Randolph 23302. An appearance for the people, please.
Good morning, Michael Kizak. People won't.
Good morning, Your Honor. Mr. Shumke is bearing behalf of my client who was present. Judge, at this time, we do not consent to this matter.
Okay, and Mr. Randolph, your name, please.
Dean Howard Randolph.
Okay, so the court will note that the court has been informed that Ms. Duff was, well, Ms. Duff, can you please unmute and state and spell your first and last names for the record?
Pamela Duff, Pamela Duff.
Okay, and why is it that you are on Zoom and not in person, ma'am?
Because I don't want to proceed with this.
Really?
Yes.
Did you inform somebody that you had car trouble? And
I did have car trouble, but I didn't want to proceed with this at all.
Well, ma'am, whether you want to proceed or not is not really up to you as far as this goes, because this is a court order that is alleged to have been violated. So you don't really get to make that call on this issue, at least for the bond violation. So why are you not in court today, ma'am?
Well, I mean, I was having car issues, but again, I don't want to proceed with this. I don't want any parts of them. I don't want to do this.
Hey, ma'am, let me just clarify. The issue that's up for today is the bond violation here, whereby this court issued an order that Mr. Howard Randolph is alleged to have violated. So you don't get the action whether you want this to proceed or not. That's something that this court would determine. Any other issues, that's on you. And so I did mute you, ma'am, because your son was making some noise, but please unmute and tell this court what kind of car trouble you were having.
I had a flat tire.
When?
This morning.
And so did your car get towed? Mr. Kazak?
Yes, Your Honor.
Mr. Shumke is not consenting to have Ms. Duff appear via Zoom. And so, Mr. Shumke, your argument for that?
Your Honor, I mean, right now this court matter was set for 8:30. It's 11 a.m. It does appear that she's not very Zoom savvy. It appears that there's a baby in the background. It appears that this is a disruptive scenario. My client has been here for the last 2.5 hours, Judge. I mean, if this proceeding is potentially being suggested to affect my client's bond, I'd ask to have an opportunity to at least cross-examine in an area where I could be able to talk to the complaining witness without fear of background noise, without having an issue with recording being subject. If I have to use it later for transcripts. Judge, this just seems to be a sloppy procedure of no fault to the court nor the prosecution, which is why if this is going to proceed, I'd ask that it just be done in fair order. I mean, if this is a scenario where we're going to be looking at my client's bond conditions, I don't think it's too much to ask that he have an opportunity to hear the plain witness in a way that would be timely, not 2.5 hours late, but then also without background noise.
All right, thank you. Ms. Duff, can you please unmute? And what time did you get your car towed?
It was like 9:30.
And where was your car when you had it towed?
94.
So you were on your way to court?
Yeah.
Okay. All right, I'm going to ask you to please mute for a moment. Mr. Kazak, your response to Mr. Shumke's objection to continue via Zoom with Ms. Duff?
Your Honor, I think that the court rules allow for proceedings to be conducted by Zoom for bond hearings. One of the obviously Ms. Duff says in car trouble this morning that's prevented her from being here. I think the Zoom still allows the counsel to cross-examine Ms. Duff effectively. Certainly, Your Honor, although there was some delay here, I think that given that the court rules do allow for good cause, I would ask the court to continue these proceedings via Zoom at the court's pleasure.
Your Honor, in this circumstance, if my client was a half an hour late, there'd be a warrant for his arrest. We're here 2.5 hours late. If there was a tire issue, it doesn't mean that there was a phone issue. I believe that my client has appeared timely. He's been respectful to the court. We've had an opportunity to have dialogues on how we used to behave in court. There has been no issue. Judge, I feel that this circumstance is somewhat unfair to my client to be in court in person, waiting timely, for a complaining witness who now appears via Zoom. I just ask that all parties be present if this is going to be a scenario so that we can make sure everything is legitimate, make sure that there is an appropriate cross-examination. And again, Judge, I'm not asking for a long adjournment. I know that our next court date is potentially in June. I will work around the court schedule if this is going to be something solidified. This just seems somewhat unfair to my client, especially due to his patience today, which has been remarkable in compared to scenarios prior to this court date, and I believe that this is going to be a marked change, which you will see it in all future proceedings.
All right. Well, I'm just trying to pull up the court rule regarding the video proceedings because it's my recollection that court has discretion as to when that may occur. Court will note under MCR 6.006 A2, a court may, at the request of any participant or sua sponte, allow the use of video conferencing technology by any participant in any criminal proceeding. And under A3, when determining whether to utilize video conferencing technology, the court shall consider constitutional requirements in addition to the factors contained in MCR 2.407. And also pursuant to MCR 2.407 B5, the court must allow other participants to participate using video conferencing technology. So the court's going to, in this case, as Ms. Duff was present, was on her making her way to court and had a flat tire that prevented her from continuing on to court, and the vehicle was towed. The court finds that that's reasonable grounds for her tardiness. The court will also note that based upon that, the court's going to proceed with Ms. Duff via Zoom technology at this point.
Judge, in this circumstance, I have no ability to produce exhibits for the complainant to view, to question, to look at exhibits. Judge, and what if it's proved that there wasn't a flat tire? What if there's evidence later on? It seems that everything is being targeted towards my client to push this through today, which at the end of the day, Judge, we're here 2.5 hours later. I'm not asking for anything unreasonable. I'm asking for an opportunity to make sure that all parties are here in person. If I need to approach with an exhibit, if I need to ask if something's been tampered, if I need to discuss a particular phone, I believe there's 3 phone numbers on these particular allegations. I just think that it's a little bit more complex than pushing through a Zoom wall. 2 of the 4 people are in person patiently waiting for 2.5 hours. I'm not asking for any sort of long adjournment. I'll work around the schedule of the prosecution, the court. I'll come in at any time, date, and availability. I just don't want to put my client's jeopardy of freedom at risk based on pushing this through last minute only because it needs to be done this morning, because there may have been a flat tire, but that wouldn't have anything to do with phone. We had a complaining witness who wasn't able to reach by her attorney, by the advocate, by the prosecution, but for now she just appears later in the day. Judge, this is a complete inconvenience to the defense, and at this point I ask for some leniency in the court to maneuver it not even a week to just another day where all parties can be present. And then even at that time, if it's not going to be allowed for her to be present and she provides proof in advance, the defense can properly prepare exhibits to have ready to present to the complaining witness while she's via Zoom. I don't have anything scanned, and I don't want to go through the procedure of scanning everything the morning of into the afternoon with other matters that I have on my agenda for the remainder of the day. My client understands that there's no contact provision. I just ask that he not be subjugated to being forced in just because now at the end of the morning, we somewhat have 2 or 4 people here, and the defense feels inabsolutely prepared to handle this matter via Zoom.
Your response, Mr. Kazak? Mr. Kazak?
Which can even then be demonstrated within the last 7 minutes. 2 of the 4 parties have had technical issues with even being signed on, one of which may have a baby in the background. Judge, I have my calendar open and we're happy to come back to the court's convenience. I just believe there was something of this magnitude with the amount of ambiguity, all the way from determining if my client contacted him with phone numbers. I understand now Mr. Kazak's back on it. I apologize for it was inappropriate to make an argument absent Mr. Kazak's present.
Okay. Mr. Kazak, were you able to hear what Mr. Shemke was arguing?
I'm sorry, Your Honor, I missed the last part that my volume cut out.
Okay, Mr. Shemke is objecting to the court continuing with yourself and Ms. Duff on Zoom because it will be prejudicial and extremely difficult for Ms. Duff to view any exhibits that Mr. Shemke may have her view in.
I know, I understand, Your Honor, and I heard Mr. Shemke's argument regarding that. I would leave it at discretion of the court at this point, Your Honor. Certainly, certainly my only concern is, Miss Duff's appearance in the future, but I would leave it at the discretion of the court at this point. Obviously, these violations concerning the fact that, we're here again. Again, I would leave it ultimately at the discretion of the court, though, whether or not to proceed via Zoom.
And Judge, if I may, I believe the next state day for Mr. Kazak would be the 18th. I do have a conflict the 18th, but I will resolve
I'm sorry
that.
to interrupt you, but it's the 17th.
Oh,
Well, it's Wednesday that week because we have the mandatory judicial
but
conference.
then I'm already here on the 17th, so that wouldn't even be a conflict. But I was indicating to the court that if it had been the 18th, I would have resolved the conflict to allow this to take precedent.
Thank you. Ms. Duff, please unmute.
Yes.
The court is going to set this for next Wednesday, May 17th. Mr. Kazak, you're already here, so that works out. And it's going to be in person, Ms. Duff.
Okay.
And the court is going to sign the subpoena that Mr. Kazak presents. And so you'll have to appear because the court's going to take testimony as to whether or not Mr. Randolph violated this court's no contact order.
Okay.
And so we will set this at 10 a.m. And in the meantime, the court's going to set a bond on the bond violation hearing. And counsel, as your argument says to bond on the bond violation.
Your Honor, my client is procedurally maintaining that innocence. I ask that he be reminded no contact with any witness, do not violating laws or ordinances, do not leave the state of Michigan without permission. He has no problem complying with those terms and conditions. I ask for the remainder of the week that remain intact.
Mr. Kazak, your response.
Your Honor, I would ask the court to increase the defendant's bond, given the allegations that the defendant made multiple contacts with complainants with using multiple numbers and that these contacts were a threatening and harassing manner. I would ask the court increase the defendant's bond pending the resolution of the hearing on the 17th.
All right. Here's what the court is going to indicate. That the court is very familiar with the parties in this matter. There have been a multitude of contacts. There have been prior bond violation or probation violation allegations that involved Ms. Duff's mom that Mr. Randolph was found not guilty on those. The court in setting bond can determine a number of factors, specifically Mr. Randolph's criminal history, any pending charges, any history of failure to appear, the safety of the public, and the safety of the victim. While Mr. Randolph has appeared in all these matters, Mr. Randolph does have, I believe, 4 warrants out for his arrest for his failure to appear. I think those are all out of the 36th District Court. I believe there's also pending charges in Macomb County with Mr. Randolph, and the court will note as well that while the court's not indicating one way or the other regarding the bond violation allegations, the court has reviewed the alleged communications, and it appears as though Mr. Howard does not, or Mr. Howard Randolph does not quite fully grasp the no contact, specifically threatening contact, which is why this court had serious concern as to the safety of Ms. Duff earlier when nobody had heard from her for a while she was apparently tending to a flat tire. The court is going to indicate a bond in the amount of $15,000, 10%. I'm going to be very clear, sir. There is zero communication. I don't care if you're trying to communicate about your child or anything else. Zero communication. Because I will tell you, the allegations with the messages that are alleged to have been sent from you are quite disturbing. This court's order is no contact. No phone contact, text message, email, social media, third party, package delivery service, UPS, mail, anything. 0.
0.0.
If you want to find out about your child, communicate through the attorney. Not from any number, not from anybody being directed by you. Nothing. I've repeated myself multiple times throughout the pendency of the cases regarding 0 contact. If there is so much as a police report alleging you communicated with Ms. Duff, Pamela Duff, the court will revoke your bond. And you will be in jail until your next court date. Do you understand all that, sir?
Yeah.
All right, well, 15,000, 10%, you'll be in custody until that's posted.
Your Honor, I understand that that amount is not going to be feasible for my client. I'd ask for the alternative potentially to a tether. I know financially that would put him in a position that he could monitor to verify that he would have no physical contact. Obviously, no phone conversation is key, and that's very clutch, but I know that my client would not be able to post that amount. And since I've been retained, or court appointed on this case, I would indicate that we speak probably every single day for at least 45 minutes. I think that that has helped the decor in the courtroom. I think that it has been beneficial to the case. My client did appear timely. Unlike any other potential times in court, there have been no issues. Anything we could do to potentially keep my client out of custody, because I know that he will not be able to have contact with me. I know that I will not be in a position to go down to Wayne County Jail every single day. Obviously, a tether would show if he even came remotely near the complaining witness, as would any sort of phone conversation. So it still would show that there was admonishment initially from the allegation, but still would allow me to maintain contact with my client and move this case along, which has had some delicate issues along the way, but it has been formed into something significantly more professional in the courtroom. And I believe that that's based on our contact. So if that on the alternative could be considered, the defense would greatly appreciate it.
Your response, Mr. Kizak?
Your Honor, I concur with defense counsel's. I certainly think that his communication with his client and his representation has been, exceptional. My only concern is, again, that these are not physical contacts with the complainant. They are via phone and via electronic devices. So tether, I don't necessarily think would address the underlying issues in this, that the underlying contact with the defendant has been having with the complainant.
And Judge, my client could still, if he were in custody, could call the complaining witness, and obviously that would be solidified and be in violation. So I think it's a step in the right direction. Obviously, we're coming back here in 1 week, and it's been made more than evident to my client that any sort of contact, whether in reply, Facebook message, tweet, Twitter, flowers, is unacceptable. I would ask that my client be given the benefit of the doubt, being patient today, being professional today, that see how 1 week with the tether, and to see if there is any obviously further allegations. It's only going to put us further down the rabbit hole and make it almost impossible to put us in a favorable position regarding a contact violation. So if it's only about maintaining and restricting phone calls, well, putting him in jail is not going to stop that if he really has his mindset on it. This at least will show an immediate admonishment. But again, we're still in an allegation and we are still maintaining innocence. And I believe that at the next court date, depending on what is shown to the court, obviously another decision could be made. A bond can be implemented at that time. But with a 1 week adjournment, and again with our maintained contact almost daily, if not multiple times a day, I believe that for the benefit of the case, it would be wise to consider, and we'd ask any sort of consideration in that matter, Judge.
Okay, Counsel, you are absolutely advocating very zealously for your client, and I will indicate that whatever conversations you've had with Mr. Howard Randolph, he clearly has had a much more extraordinary behavior and court appearance this week than on April 20th. However, the court set a personal bond initially, and there alleges to be some issues with the ability of your client to follow the court orders. And based upon the totality of the circumstances, the court finds that your client having a monetary interest in his bond would be a significant motivating factor for him to follow this court's orders.
Could it potentially reduce to something more feasible? Because I know that my client cannot post $1,500. And I was in the process of asking him, but I stopped that conversation as the court was instructing my client that I wanted to make sure that the court had my client's undivided attention. So potentially a lower bond, which would still put him financially, because at this point, $1,500 might as well be $15 million. He doesn't have it. So a lower amount would still provide that monetary incentive. And again, it's only a week adjournment.
I understand that. But what I'll do is I'll convert the $10,000 personal bond to be $10,000, 10%. So the court's also going to indicate that in the event bond is posted, GPS tether, and no contact by any means, then May 17th at 10 a.m. is the date.
Thank you, Judge.
Thank you. Ms. Duff?
Your Honor, is this
Yes.
Sherry, would he be allowed to get a bail bond in on this particular case as well? Just in case, because he's given me his girlfriend's phone number. I'm even potentially in a position where I'm going to try to coordinate, but he indicates she might be sleeping. I just asked that if I can reach her that bail bonds would be a consideration.
10,000, 10%, no surety. That's even less than 10%. And the court wants there to be some financial motivation for your client to follow this court's orders this time. Ms. Duff? He's on mute, Ms. Duff.
Yes.
May 17th at 10 a.m. And I'm going to instruct you not to initiate any contact with Mr. Randolph if that has been the case. Any communication regarding your son can go through your attorney.
Your Honor, one other housekeeping note is my client has court regarding this today. And I know that that's going to be a significant burden. The other court has seemed to give a lot of clearance for this particular matter, which I completely understand, and move back the proceedings. But if he goes into custody and he indicates he's not going to be able to post even that $1,000, he's going to miss that proceeding. And I'm not the attorney of record to contact that court. I have no authority to provide jurisdiction or ask for an adjournment. Seems like we're just creating more ripples that are going to not conclude what should be a beneficial meeting or court appearance between my client and the complaining witness. As that was scheduled today, I'd ask for any sort of other consideration to allow my client an opportunity to maintain his freedom and go to the court appearance that was scheduled today that has been waiting on his appearance, obviously with consideration that there be no contact. I can only zealously represent as much as I can in the circumstance, but it does put him in a precarious position. But I would note that he has been very professional day, and he's been here timely. And going into custody would be certainly detrimental to the case, which has been waiting on him. I can't speak as to what the docket looks like now, but I'm certain after being in that court before that they're patiently waiting on him and he will not appear.
Okay, Ms. Ozier, would you like to address the court? If you can start forward, please.
Yes, Your Honor, I am representing Ms. Duff in the custody matter, and with regard to Mr. Howard Randolph potentially being in custody, that was something that we did inform the judge of yesterday, and he said that he would accommodate as necessary if that is the case. I plan to appear as soon as I am back to my computer to inform the judge of the way that these proceedings conclude. I would also like the court to note that while it's been made clear to Mr. Howard Randolph that there is no contact electronically or by other means, that throughout the trial proceedings, Mr. Howard Randolph has continually directly addressed Ms. Duff during these proceedings, which would violate the no contact. And I believe that that will continue to happen. The decorum of Mr. Howard Randolph today might be great, but throughout the Zoom trial has not been great, and he has made threats and has spoken in threatening ways to myself as well as Ms. Duff.
And when you indicate that Mr. Randolph has been addressing Ms. Duff directly, is that during Mr. Randolph's turn to ask questions? Is he representing himself?
He is representing himself. It has not been with regard to any direct examination of Ms. Duff. He has not chosen to, at this point thus far, to question Ms. Duff personally or cross-examine her. This has been in his statements to the court, which then devolved into him directly addressing Ms. Duff.
And Your Honor, we're going to be in the process of getting the transcripts of that particular hearing this week. We don't know the specifics. If the court were not be inclined to reduce further, I would only ask for this one allowance that my client just financed a vehicle. It's in the parking lot. Is no one else to get the vehicle. He asked if I'd be willing to drive to his address. I indicated that it doesn't fall within the things that I'd be willing to do. I asked that my client get a report date later today, if not tomorrow, so he can just take the car back. Because not only is he going to be missing the hearing, he's going to be going into custody. I don't want him to be in a position where his car gets towed and he's going further and further down an avenue that we're just trying to halt and put back into an advantageous position. He understands that if he fails to appear, the consequences are going to be it's going to be a catastrophe. So that would be the only allowance if there'd be no bending on any further bond conditions, that he be able to report in custody after taking his car in.
Okay, and I can appreciate that, counsel, but Mr. Randolph can leave his key at the window with the police department, and we can make sure that they're not having it towed, and then his girlfriend can come pick up the key later with the vehicle. I'm not giving him a report date, not at all. I have serious concerns for safety and compliance with this court's order. So the court is indicating 10,000, 10%, no surety, GPS tether in the event bond is posted. You can leave your key with the police department, and then we'll make a note that with what your vehicle is, so that it's not towed and that somebody can pick it up within the next 24 hours or so.
Not say something for the courts.
That's up to your attorney.
Well, that's up to me, y'all. I got my own mouth. Please, you already do what you want to do, bro.
Sir,
It's okay.
let me just be very clear.
Mhm.
Your attorney would advise you whether or not you should or should not address the court based upon what it is you want to say or not.
Allegations.
Because
So.
because-
Continue commission.
You're interrupting me.
Okay, go ahead.
Because something you say could be used against you.
Mm-hmm.
So that is why I indicated if your attorney
Mm-hmm.
suggests that you
I'm
speak.
saying nothing wrong. I'm just saying the Michigan Tenure Commission needs to hear about this.
Okay, now I'm holding yours in contempt. I've already indicated that you are not to interrupt this court. Yeah, you have continued to do so. I've given you one chance. I've given you one chance right now. The court is going to indicate pursuant to MCL 600.1701 that you are engaging in disorderly, contemptuous, insolent behavior during the immediate view of this court and in the court's presence, directly intending to interrupt its proceedings and impair the respect due to its authority. Further, that under MCL 600.1701B, that this court finds you are in contempt during any breach of the peace, noise, or disturbance directly tending to interrupt this court's proceedings. The court will also indicate that this has occurred in the presence of the court. Therefore, the court may punish you summarily by fine or imprisonment or both. Stop interrupting, sir. Therefore, the court's going to indicate 15 days jail for contempt. Damn! The court's going to also indicate that while, sir, you were quiet and not interrupting this court's order, nor the proceedings, towards the end of the proceedings, then you began to interrupt this court. Despite this court's order not to.
Not to speak my mind.
Not to interrupt this court. Therefore, as is evidenced still by your continued interruption of these proceedings, the only corrective action necessary to restore order and maintain the dignity and authority of the court is to hold you in criminal contempt and sentence you to 15 days jail.
Okay. But hey, you filed a false police report, you let it get in your courtroom, so did the prosecutor and the team.
Sir,
and it's already, you got a grievance on you already right
sir,
now.
You may file anything that
June
you
the
choose.
1st, hey, listen,
You
this
may
domestic violence.
stop interrupting.
You're gonna
Stop
get
interrupting.
guarantee that.
Okay, well, at least you're helping the court make a record for yourself, for the court as well, as to why this court found you in criminal contempt. We'll see you next week on the 17th.
Baby.
You're not to address,
Okay. I'm addressing the bar though.
sir, the court's adding another 10 days time for you addressing the victim in this matter. It's all 25 days. Off the record.